The general public would probably assume that contracts are all about good faith. Is there a concept of good faith in English law?
Well, many lawyers would say, good faith, English law, there's no such thing. English law has been famous for not having the concept of good faith. Good faith is part of American law, it's part of continental law, and we famously don't have it in the UK. But actually we do have it. We just do it in different ways and in bits. So we have a concept of misrepresentation. We have protection such as estoppel to help in the most difficult circumstances. But it is true that we don't have, until recently at least, an implied or general duty to use good faith. That's all been changing over the last year. We've had two big cases, one to do with catering outsourcing at a hospital called Compass and Mid-Essex, and another case called Yam Seng, which is all about the distribution arrangements for Manchester United eau de toilette, would you believe? In those cases, they discussed about whether it was possible to have a duty to use good faith. In the Compass case, there was a clause that said the parties will use good faith, and eventually in the Court of Appeal said, yes, this clause can mean something, but it's not going to apply to this particular set of facts. It looked at it very narrowly and narrowed the junior court's approach to it. So the Court of Appeal said, good faith, yes, it can mean something, but we're always going to interpret it narrowly and carefully. In Yam Seng, that was about a distribution contract where there was no reference to good faith in it at all, and the judge looked at that carefully and extensively, and he identified that it was possible to have an implied duty of good faith in an English law contract. He said there was precedence for it both in the UK but also in other courts such as Australia and Canada, and he therefore said that in certain types of contract, not all, just certain types of contracts, it was possible to imply a duty to use good faith. The types of contracts he gave as examples of where you could imply a duty were joint ventures, collaboration agreements, and distribution agreements. And I find that very difficult to understand. My experience is that joint ventures and collaborations, people do usually want to collaborate and work together and be nice to each other. But distribution agreements, usually, my experience, the principal and distributors are on very different sides of the field and rarely use any form of good faith at all. So to find a judge suggesting that they are a type of contract where it's an essential ingredient, I find very difficult to understand. But he did, and he found that the principal was in breach of this implied duty to use good faith. The Court of Appeal in the Compass case looked at Yam Seng and said, yes, we can understand where you're getting to, but we don't think it's too relevant much of the time, and they narrowed its application. So we're in a place now where if you use the words good faith in the contract, the courts will say it means something. You're just left with a dilemma as to exactly what it does mean. Court of Appeal indicating that will give a narrow approach to it. If your contract says nothing about good faith, then my reading is that usually the courts will not imply an implied duty of good faith. But if it's a particularly close or collaborative arrangement, that is possible. Pragmatically, I can't see it's commercially possible really to specifically exclude an implied duty to use good faith. I think if you said to somebody, I'd like to make it clear in this contract that I have no obligation to use good faith at all in any of my dealings, that would get a pretty negative response.
You say that express good faith clauses work. Would you recommend using them in a contract?
I would avoid it. If I had the choice, I would be silent on it. I would not say anything about good faith in a contract because I'm not sure what it means. And my experience in negotiating contracts is that it's not the lawyers who've sought this general obligation to act in good faith. It's the commercial guys saying, hang on, we would like to be clear that we all want to get together and be nice and warm and cuddly, which of course everyone is when they're negotiating the contract. But I think you live to regret that if the contract falls apart. I don't think many contracts actually need an express general duty to use good faith to make them successful.